All right, thank you once again. I think we have one more case. And just for the record, Judge Jill Ayers has rejoined us for the session. Madam Clerk, you may call the next case.
John David Smartt versus State of Tennessee.
Good morning, Your Honors.
Good morning.
My name is Christopher Beauchamp. I'm a member of the Wilson County Bar, and I'm here on behalf of John David Smartt, the appellant. I would like to reserve 3 minutes for rebuttal, if the court please. And just to provide somewhat of a very generalized summary of how we've arrived here today, and also I would like to thank you all for the opportunity to come here, and this is my first time arguing in person.
Well, welcome.
I had one Zoom argument with the Court of Appeals, and so this is a great opportunity and I appreciate it. But getting back to this particular case, this is a post-conviction appeal. Mr. Smartt filed a post-conviction petition alleging primarily that he received the ineffective assistance of counsel by his trial counsel in 2016. Mr. Smartt was convicted of a plethora of sexual-related offenses and ultimately sentenced to 153 years in the penitentiary. He did appeal it directly and raised several issues. One of the issues raised in the direct appeal I have represented to this court and to the post-conviction court on the basis that it was ineffective, resulting in the waiver of that particular issue and not appealable at the time. And that issue, well, preliminarily, I suppose, one of the issues that I raised in the brief was that the order issued by the post-conviction court did not comport with Tennessee Code Annotated 403211, I believe it is, and Supreme Court Rule
It's okay.
28-9,
yeah.
right?
Yes, that the trial court, or excuse me, the post-conviction court is required or shall issue its findings of facts and conclusions of laws.
Tell me how it is prejudicial to you or how that impacts your argument. Because the trial or the post-conviction court here, in my view, panel may disagree, gave fairly extensive, I guess, a ruling on the issues that were presented at the evidentiary hearing, the post-conviction evidentiary hearing, such that the issues that were raised were fully fleshed out. So speak to me on how you think his failure to comply with the rule impacts review of your issues.
And I would agree with Your Honor in the sense that the judge's oral ruling at the conclusion of the post-conviction hearing did sufficiently set forth his findings as it relates to the argument and the law that applies to the testimony that was given. I suppose the reason why I raised it before this court was more of a procedural technicality than it was anything necessarily determinative towards the outcome.
I appreciate your candor. Okay.
And so moving on from that particular argument, I think, and I would submit to the court that probably the stronger of the two arguments relates to the failure to object to Detective Rowland's testimony about the phone call between the appellant and the victim in this case.
Okay, so I want to back you up there.
Sure.
So your client, the first jury trial ended in a hung jury. Yes. And that is when this issue was first fleshed out.
Yes.
There was a motion in limine, is it my understanding, concerning this recording?
Yes.
And so all of that was fleshed out prior to the mistrial.
Yes.
Is any of that in the record?
Other than an acknowledgement by trial counsel the Assistant District Attorney and Judge Stanley in a motion in limine that was orally submitted to the court at the commencement of the second trial.
So there was just a reference back. I saw that. There was a reference back to it saying that it had been. But in terms of what was done, was that in the record?
Not with particularity, I don't believe so, Your Honor.
Okay. You may proceed.
Yeah, thank you. So what I would submit to the court is that trial counsel had raised that motion in limine trying to address the phone call, because Your Honors may recall from the briefs in this case that this phone call was a controlled phone call that oftentimes happens in these sorts of cases where the victim reaches out to the alleged perpetrator of those crimes and tries to get that alleged perpetrator to acknowledge some of the various circumstances that are being alleged. And this was a controlled call, which indicates that what she stated in the phone call was captured, and what he responded to the allegations should have been captured, but they weren't. And so the only thing that defense counsel had with respect to that phone call were her allegations. The only thing that the jury would have heard, if they heard it, which they didn't because it was excluded, would have been her allegations. And there's really no way, as we sit here today, that defense counsel can adequately defend and cross-examine her on what his responses were, because we don't know what they were. And going to that, it's my recollection that specifically when the victim testified, she was asked about the controlled call, and then General Minor stood in and said, "Don't talk about any of the responses. I don't want to know about any of the details, but was there a controlled call?"
Okay, I'm going to kind of get you to
You're gonna go where I'm going.
focus. Yeah, go ahead. You can go ahead,
But
Jim.
is that actually in the record?
It is.
Okay.
Okay, so, are you done? So, this record was challenging to me. And my question to you is, did trial counsel object? Does the motion in limine qualify as an objection to the information in Detective Rowland's testimony? Because my understanding of the record is the victim didn't testify about the recording.
She testified that a recording took place, but she was prohibited from testifying about the details or contents of it.
Okay.
Detective Rowland would have been under that umbrella of any knowledge related to the phone call, of excluding that. And there was a question that General Minor had asked, did the alleged victim, or the victim in this case, indicate to you that during the conversation that the appellant had in fact made admissions?
Mm-hmm.
And Detective Rowland says that is what she told me. And so there was no objection contemporaneously with that.
I agree.
And there was an opportunity, and
But he objected ahead of time to this
Yes.
whole thing,
He did.
right? Okay.
And respectfully to trial counsel, I believe that there is some indication from him in his testimony at the post-conviction hearing that oftentimes when there is an opportunity to raise an objection, that sometimes he won't do it because it draws attention to the specific question that's being asked. And I would submit to the court that based upon him raising the issue on appeal and him raising the issue before the testimony comes forward, that it would be unreasonable to believe that when that testimony is trying to be drawn out, that he's making a tactical decision not to object. If it was important to exclude it before and you want to raise the issue after, saying that that is strategic or tactical is unreasonable, I would submit to the court. And as far as the other prong of Strickland as it relates to that particular argument, we have a situation, and as I briefed it, where there are a number of egregious allegations against my client. And it was all testimony from the victim, but in terms of any other individuals that had any firsthand knowledge of those particular allegations, it all came from her telling them. There is some circumstantial evidence that, I saw them, going off into a room or this or that, but there wasn't any physical corroborating evidence or third-party witness evidence that necessarily indicates that any of these things occurred. And in fact, one of the things that the victim testified to, and several of the convictions are based upon, the sexual exploitation of a minor charges, is that there were photos and videos and other things that were taken of those actions. And when a search warrant was conducted and forensic analysis of the electronic devices were completed, no such evidence to support it was there. And so going back to how does this one sentence answer prejudice the outcome of the case, is that it sneaks in to the jury's minds that the appellant in this phone call admitted what she's saying he did. That he admitted it. And so, while I have a little bit more time, I'll transition into the other argument. And I know that there...
My facts on this case, just so I'm clear, the victim did say that he confessed to her, not in the recording. The victim talked about admissions throughout her testimony. Did I have a recall on that? I might. We see a lot of these. Because I didn't see, when I looked through it, I know they were mindful of her testimony concerning the recording. And I'll have to go back through. I just didn't know if you knew off the top of your head. If you don't, that's fine.
There may have been some, and I'm trying to remember based upon the transcripts that I have read in this case, but there may have been some indication of an apologetic nature. But again, by virtue of only partial completeness of this phone call and not being able to address and understand what his responses were to that phone call, and not objecting, I believe, or I would submit to the court that he was prejudiced as a result of it coming in. Secondarily, and again, I appreciate that Your Honor pointed out that this was the second trial, that they went through 2 days of testimony and a jury came back and it was a hung jury. And so I would submit to the court that while there are some cases that deal with whether or not a defense attorney has an obligation or a duty to prepare their client for giving testimony, I believe that and whether or not, that has not been found to be ineffective assistance of counsel, that if you don't prepare your client to give testimony, that they're not entitled to relief. I would say that this case is unique in that it was tried twice.
And he got on the stand, and there was a moment hearing conducted twice. He signed a waiver twice. I'm not sure I'm following your argument that the mistrial makes it more probable that counsel was ineffective.
Yeah, it almost seems the opposite to me, that he'd been through this, he knew what it was going to look like. He actually, the appellant actually had more time and opportunity to become knowledgeable and aware and have these conversations with counsel about his role and all of that.
I understand. If I may address that, it's so in situations like these, and I'm sure you all have seen hundreds of cases where it's essentially a swearing match, he said, she said. I would submit to the court that after going through the first trial, at that point, when you don't get an acquittal, you need to reevaluate whether or not it becomes important for the defendant to testify in his own defense.
Well, on the other hand, I mean, he at least had some of the jurors thinking the first time, right? And he maybe figured he'd draw a more favorable jury, but obviously he had them thinking enough to where they couldn't come to a conclusion.
And I suppose that is why I said that my first argument, I think, has greater strength, and I would submit to the court than this does. But with respect to that, I believe, or I would submit to the court that trial counsel's testimony at the post-conviction hearing with respect to preparing the appellant for giving testimony in this case was that ordinarily with his clients he'll do like a mock trial sort of experience where he'll throw questions at them, but he couldn't remember precisely whether or not he did spend any time preparing Mr. Smartt for giving testimony. And Mr. Smart's testimony was that his attorney did not. And I know that the burden on factual allegations in a post-conviction petition hearing is by clear and convincing evidence. The absence of any sort of certainty with respect to preparing the appellant for giving testimony, and then the testimony that the appellant provided in the post-conviction after adequate preparation was provided, the testimony that was fleshed out during the appellant's testimony in the post-conviction hearing, and the information that he provided, I would submit to the court, would indicate or would likely change the outcome of the trial had he testified during it. That's clear as mud, I'm sorry. And so I would submit to the court that as we sit here today, that the trial court or the post-conviction court erroneously denied the petition. And I would ask the court to reverse the court's determination as it relates to the appellant not being entitled to any relief in this case.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court, Brooke Huppenthal on behalf of the state. Because it appears my friend on the other side has conceded on issue 1, unless this court has further questions regarding the remand, I will move on to the issue of objecting to detective.
I don't think he conceded, but he does acknowledge he just raised it for procedural purposes.
Yes, okay, and I'll briefly address
Yeah,
it.
I didn't intend that for you to use your time, to waste your time on it. When I ask that question, it's for the purpose of knowing how much time we should spend on it in an opinion. So, but
Yes.
you choose however you want to spend your time.
Of course, Your Honor, and I'll briefly address it. The state would argue that the record is adequate here for the court to review. We have the archived trial record, the post-conviction hearing transcript, which also contains the court's findings, and the petitioner also acknowledges that there are sufficient fact findings regarding the proof, and that these are two straightforward ineffective assistance of counsel claims. And when we take the facts as the court found, it necessarily resolves both of these issues. And I will move on to the first ineffective assistance of counsel claim. The petitioner alleges that Mr. Crane was deficient for failing to object to the testimony. However, the proof shows that he strategically decided not to object. He testified that he wanted to avoid raising the jurors' awareness to the issue. And just for a brief comparison, when we look at what the victim had testified to, she stated that he had made admissions, and I believe it was about tying them up, I think she said. There were no implications of any sexual allegations as she had testified about his statements. And Detective Rowland's testimony, here the prosecutor had asked, did JS indicate to you that during that conversation that Smartt had in fact made admissions? Detective Rowland responded, yes, that's what she told me. That's the one statement challenged. It essentially already came in through the victim's testimony. The post-conviction court found that, and the court also agreed that there were instances where attorneys might want to avoid raising a juror's awareness about a certain issue, and the court agreed that in this case that it would make sense, particularly considering the victim's testimony here. There also isn't any proof of prejudice. He's arguing that the issue was weighed for appeal and allowed the evidence to become admissible by failing to object. And just to give a little bit of background, because I understand that there was the motion in limine in this case, and this court on direct appeal discussed that motion, and it said that the court said he had waived it on appeal by failing to object contemporaneously. It also is referenced within the hearing transcript. For transparency's sake, I did not go through the trial record. However, going off of this information, the post-conviction court held that the court's confusion with the law appears to indicate that regardless, it didn't feel like it had to reconsider the ruling. But
Well, I'm going to help you, because what the court said was it was properly objected to and preserved.
yes.
Now, the question is, in my mind, what grounds? What grounds was objected to previously that the trial court had ruled the state was not supposed to get into this, okay? And because this was all fleshed out prior to the mistrial, I don't know that we will ever know that. So I'm helping you there, because the trial court here seemed very upset that this court on direct appeal had ruled it had been waived. And I believe, I don't know with certainty because we don't have it in the record, it was waived on a different ground than what the trial court had recalled, if that's helpful. But go ahead.
So I hadn't addressed that issue, and I'm more than happy to provide supplemental briefing and to dive into it if necessary. But what the trial court had held is that this recording is excluded. It's the testimony about the recording that can come in. So because of that holding, the victim was allowed to testify briefly about some admissions made, and then later on, Detective Rowland had also indicated, without stating the content of the call, that some admissions were made. But if we look at the issue, these were the defendant's statements, and I understand that there's double hearsay going on here. However, when we look at the prejudice element, there's no evidence that this brief statement did anything to impact or change the outcome at trial. There was overwhelming proof, and I know the petitioner cites that or describes the case as a he said, she said case. However, it wasn't that. It wasn't just the victim's testimony we have here. It's the journal that had this, the statements from the petitioner's wife stating that that she had believed her daughter about these sexual allegations. And it was significant, and the victim went into excruciating detail about every instance. And when we look at this one sentence statement in light of the proof, there is no evidence that it ultimately impacted the outcome at trial. And the petitioner also doesn't explain how the proceedings would have been different if Mr. Crane had objected to this testimony. And if the court doesn't have any further questions on this issue, I will move on to the failure to prepare to testify. The petitioner had never expressed interest in testifying. He, at the post-conviction court hearing, explained that he had trouble articulating his thoughts, he was inexperienced in public speaking, and he was afraid of the prosecutor's cross-examination trial, and he explained that those were the reasons why he did not want to testify. The court also found additional reasons on top of those why the petitioner didn't testify, and that included seeing the proof against him at both trials, watching the cross-examination of his wife, because ultimately she was cross-examined very intensely about the journal.
Can I back up just a minute?
Yes.
Because what you said earlier on the trial court's ruling on the recording,
Yes.
you said that the trial court had admitted the recording?
It did not admit the recording, but it allowed the state to introduce testimony about the recording.
Okay. Help me with that. How does that work? Just that there was a recording?
There was a recording, and the issue with the recording is that it had only recorded the victim's line.
I guess what I'm trying to get you to answer is, what was the trial court's ruling from the state's perspective before trial on the recording?
That was my understanding. That was the pretrial ruling.
What?
That the recording was not admissible.
Okay.
And that testimony, though.
Okay.
Yes,
that's
so,
fine.
my
Yeah,
apologies, yes, and I hope that answered your question.
It does.
Okay, perfect. Briefly going back to the failure to prepare to testify, we don't have prejudice, proof of prejudice in this case. Again, like, the proof would have been quite damaging based on his testimony at the post-conviction court hearing. He stated that he had assisted his wife in trying to get rid of the journal. He thought that he had burned the journal. That ended up getting introduced at the second trial. And he would have been cross-examined on that information. And while the prosecutor at the post-conviction court hearing didn't question him on this, there was some evidence, there was some proof that the devices that had recorded these images, the pictures, were destroyed before the detective had executed the warrant. And those all would have been available cross-examination questions. And ultimately, the court found that the journal was quite detrimental to the defendant's case. That was really the pivotal evidence. That was the difference between the first and the second trial. And based on his wife's testimony, cross-examination, it's clear that the petitioner would have undergone equally challenging cross. And additionally, the court proposed that Smartt claim that his decision not to testify ultimately worked against him, and this is not a permissible avenue for relief. And if the court has no further questions, the state asks to affirm the post-conviction court's denial of relief. Thank you.
You have your rebuttal time.
I hope that this may clarify to a certain extent, without necessarily giving your honors the trial judge's specific ruling. There is on page 198 of the original trial transcript some question and answer that goes on direct examination by General Minor with the victim in this case. And it starts with her testimony saying, so I called him and directed the phone conversation directly to that being the allegations of sexual impropriety. What he said he wanted to apologize for, what do you want to say to me? And he kept apologizing to me. He kind of talked about a few of the things that he did as far as, tying us up in the room and things like that and saying, and then General Minor says, what do you mean tying you up in the room? That sounds like something different than I think what you're going to describe. She answers, well, he would tie and then a sidebar occurs. And defense counsel and Mr. Minor approach, they have a bench conference that's not contained in the record. And then they return to the questioning where Mr. Minor says that the alleged victim, or the victim in this case, is unresponsive to the question. And he says, JS, we have rules. We talked about that before. What I What I'm asking you is just to tell me about your end of the conversation, not any specific responses that your father made. And I would submit to the court that that is an acknowledgement that's in the record, providing an illustration that the appellant's responses in that controlled call were inadmissible in addition to the controlled call. She could testify about the controlled call taking place, but she was prohibited from testifying about what his responses were. And it may be maybe Merriman or a Ferguson issue where it was an incomplete electronic record, and because of its incompleteness and due to whatever the negligence or intentional actions of the detective with respect to that is the reason why it was excluded and there wasn't any testimony permitted for it.
Okay, so we're talking about a different ground. That's all I was trying to get at. It was a different ground that it was excluded under the victim's testimony as opposed to what you're raising in this appeal for Detective Rowland's testimony.
Well, the same grounds would exist as it relates to all parties, all witnesses are prohibited from testifying about the appellant's responses to the allegations made in that phone call, which includes Detective Rowland as he sat there, as he sat there and listened to the one side of the conversation. And it's also important to note that in this conversation, he didn't hear any of the responses. He only heard one side of it. And so the information that comes to the jury is that she told him that he made admissions. And whatever those admissions are, it might be, I took away your cell phone, and I'm sorry about that. We don't know, and the jury is tasked with assuming that his admissions are related to sexual misconduct.
All right, you can conclude. Thank you.
Thank you, Your Honor.
You can just wrap up.
Okay, and so just to touch upon the other preparation aspect where Mr. Smartt said that he didn't want to testify because he was scared of cross-examination and the other reasons, I would submit to the court that with adequate preparation, those concerns should be alleviated if you spend time with your client. And so for those reasons collectively, Your Honor, Your Honors, I would respectfully move this court to grant the post-conviction petition and reverse the convictions in this case.
All right, thank you, counsel. Case will be taken under advisement and will be in recess until 1:30.
Yes, Your Honor. All rise.